Good afternoon, everyone. My name is Lluc Cerda. I'm the managing partner of the Calgary office of Samfiru Tumarkin. I'm a lawyer here at Samfiru Tumarkin, specializing in employment law, and we're here today to answer your employment law questions and answers, the employment law Q&A. We're here for the next half hour to answer any and all questions you have related to employment law in BC, Alberta, and Ontario. So I'll try to get to as many of the questions as I can with you today. Put them into the chat that you have in front of you. I'll try to answer as many as I can today. We have a question already coming in from Sophie. Sophie is asking, what can I do if there are many mistakes in the LOE given to me? So LOE, what I think you mean by that is loss of earnings, Sophie, which oftentimes, if I understand correctly, has to do with WSIB or potentially long-term disability. It would be important to clarify with either WSIB or disability, that this document is factually incorrect. If the employer continues to maintain, for instance, that your hourly rate was X when in fact it was Y, and that affects how much loss of earnings you receive, and definitely that's where you can get one of us involved. Probably someone on our disability side might be able to help you more with that than someone on the employment side, but there's definitely someone at the firm who can look into that for you and help you out. So if you're looking to reach out to us based on what you hear on the show today, the best way to do that is reach out to us at the website on your screen, which is employmentlawyer.ca, employmentlawyer.ca, and we'll try our best to help you out as best we can. We have another question coming in from YouTube from Dan A. Dan is asking, I'm a sales rep in a big company in Alberta that's federally regulated, entitled to 2 weeks vacation. My boss wrote me that I can only take a week at a time and I need to travel overseas. This is not in the employment agreement. Okay. So if you're struggling with your employer on when you can take vacation, the law actually, as it stands in Alberta, is that you and your employer have to agree on the date, okay? And your employer can require that you only take these 1 week at a time. That is in the law. It's unfortunately allowed. In terms of it's not in the employment agreement, basically maybe if you had a past practice of taking more than 1 week, then you can make that argument that, the past practice has been that you can take more than 1 week at a time. There are several employers that limit how much of your vacation time you can take in one go. That's a discussion you'd have to have with your employer, even if it's not in the employment agreement. From the perspective of what an employment lawyer can help you with in this regard is if it amounted to a constructive dismissal, then you might be we might be able to help you get a severance. For these things that don't amount to a constructive dismissal, where there is a change to your working conditions, but it's not a big enough change to warrant you quitting and pursuing your severance, you're really left to deal with this with your employer. Your employer actually has a lot of control over how the workplace is run. It's only when the changes that they're proposing become very serious that we can get involved, or the law gets involved really, and making sure that this is appropriately addressed. But in terms of managing the day-to-day, vacation policies and things like that, beyond what is the bare minimum that's written into the Employment Standards Code of Alberta, there isn't much else that a lawyer or the law really can do to change that policy that the employer has. So it's to have a discussion with them. And ultimately, if it's really causing you problems, your only option really is to just go find work elsewhere if they're not willing to concede to your demands, unfortunately. It's not always the case, but on something like this, I don't know if a court could really help you out, or the law could really help you out, force your employer to let you take 2 weeks off instead of one in a row. I have another question coming in here from Stavrob1. Stavrob1 asks, can my employer remove half my portfolio and then reassign me to another department through reorganization? This is a non-union job. Is it constructive dismissal if salary remains the same? So yes, Stav Rob, sorry, it can amount to a constructive dismissal if your portfolio is reassigned. It's more for senior employees, so that would be um, uh, um, that would have an impact. So, for instance, if you're reassigned from, say, accounts receivable to accounts payable, or just generally accounting, that might not amount to a constructive dismissal because your clerical tasks are still clerical in a sense. But if you're in sales, for instance, and they take away this portfolio you've been building for years and years that you have relationships with, then that can amount to constructive dismissal. It's even more so if that portfolio is tied to your compensation. Say you receive commission payments or bonus payments based on what you generate through your portfolio. To take away half of it is obviously going to have an impact on your compensation. Here you say they're not really changing your compensation, so we have to have a bit more detail then of what exactly is changing here. Uh, what department you're going with, what's happening to that second half of your portfolio, are you keeping it? Get a bit more detail. So constructive dismissal, the law says, is very fact specific. So we'd have to have a bit more details about your case, about what's happening to you, to know if this amounts to constructive dismissal. I'm not shutting down the door just yet based on what you told me, because it could be that I hear things like I'm losing half my portfolio. It gets me thinking for sure. So definitely you'd want to reach out to us, give us a bit more of the facts so that we can properly assess whether this amounts to constructive dismissal and whether you're entitled to severance. And we have the website on the screen there for you, employmentlawyer.ca. So feel free to reach out. We'd love to discuss this with you. We have another question coming in from YouTube from CS. CS is asking, can my employer force me to attend an offsite company meeting? Is this legal grounds for termination? So, great question. So you're looking at it from a different perspective than our earlier question from Dan. So I was looking at Dan, whether he could claim constructive dismissal for being refused 2 weeks off in a row. You're basically asking what'll happen if I just don't show up to this meeting. If I, instead of asking for permission, I ask for forgiveness. So it's definitely a risky proposition to not show up to work. I'd like to know more why you don't want to go. If there's family obligations or you don't feel comfortable spending all this social time with your colleagues, I'd like for there to be some sort of reason other than I just don't want to. Because although it's definitely not going to amount to job abandonment, you could face discipline. If I were advising your employer, I would say, yeah, the discipline has to be short of termination. It has to be either a warning letter, maybe a suspension at best, but missing a firm event when I don't know, it would amount to cause. But you'd have to have some sort of reason why you don't want to go. And so we have to kind of address whether that reason is supportable. If it is supportable, for instance, you have childcare obligations, you can't absent yourself for several days in a row, then I don't think you should get any discipline. I think you should just state, well, listen, I can't just get up and leave. My job has always been to go home at the end of the day. It's never been a requirement that I travel for work, and I don't want to do this firm seminar or firm retreat that you're proposing. So I'd love to hear what reasons you have against going to the retreat, what you don't like about the idea. But you're right. I don't think this would amount to cause for dismissal. All right. So, but always before you get into what's going to happen to me, try to be transparent with your employer as to why you can't go, right, and explain that to them. All right. We have Stavrab is following up that he's in Ontario, actually. So, okay. So Stavrab's in Ontario. I don't know if my answer really changes if you're in Ontario, Stavrab. I'm also licensed to practice in Ontario as well as Alberta. And yeah, I hear things like I'm losing portfolios. You say it's a transfer to another department. It could potentially be a demotion as well, or a loss of, just losing prestige and status can amount to a constructive dismissal. So I definitely think that there's enough there that you should call us if you're concerned or if you're ready to quit, so that you can maybe get some severance as well, because this could amount to a constructive dismissal. I'd like to get a little bit more understanding there. So nice compliment from Sam, who says that this is great content and channel and very informative and engaging. Well, Sam, it's because all of you are so engaged, giving me some great questions to answer, and I really enjoy doing the show, and your compliment makes it even more worthwhile. So thanks for listening. And if I don't get to everyone's questions today, we have these shows several times a week. Next Wednesday, this coming Wednesday, is the next show that we have, and it's the man himself, Lluc Cerda, who will be answering your questions as well. So if I don't get to everyone today, don't lose hope. We'll have more shows coming this week. So Sophie has clarified. Sophie was asking me, what can I do if there are many mistakes in what is now, I understand, a letter of expectations given to me. So letter of expectations is also a little bit of a new term for me. Employers have all sorts of different nomenclature for what they use for discipline, and I guess this is what you're referring to, Sophie. So you've received some sort of discipline, potentially because the employer is saying you're not performing up to the standard of what they're looking for, and they're looking to set expectations for you. And the reason employers do that is because before you can terminate someone for poor performance, you have to give them a chance to fulfill the performance requirements of the position. And part of that is explaining what the performance requirements, what the performance expectations are. So definitely in this case, Sophie, I would clarify with your employer these mistakes in the letter of expectation. If I now have this correctly, that this is in relation to what they are terming some lack of performance on your behalf. So definitely clarify that. You want that to be as clear as possible, so that you know what your expectations are and what their expectations are of you, rather. So definitely important to speak to your employer about that. Absolutely. We have another question coming in from Frank Kahn. Fred Kahn. Fred is asking, hi, I am a 66-year-old. I worked in skills trades for the same company for 11 years. In terms of severance entitlements, how many months worked? 54 hours, I guess 54 hours a week, 90%. Should they pay bonus and RSP contribution too? Okay. So a great question, Fred. Actually, this is an opportunity for me to point you towards our free to use severance pay calculator that we have online at pocketemploymentlawyer.ca. So if you go there, you answer 4 easy questions. We'll give you an estimate of what you might be entitled to in terms of severance. So, Fred, I think that in actuality, you would probably be entitled somewhere in the range of 11 to 15 months of severance if you were terminated today on a without cause basis. Okay. In terms of what comes out of what makes up that 11 to 15 months, how do we transform that into dollars? What we would expect to see in any offer your employer would make to you would be compensation for, of course, your base salary. You seem to be working on an hourly basis, which is often the case in trades. I'd like to see if you're someone who's entitled to overtime. Some employees are overtime exempt, especially if they work in the construction industry. That's an overtime exempt category, so you don't get overtime. Doesn't mean you don't get paid for hours over 44 hours a week. You still get paid, but only at your straight time rate, not the overtime 1.5 rate. But basically, you'd be looking at what you would have earned over that 11 to 15 month period. And if it's likely that you would have continued to work 54 hours a week, then your salary, your severance should be based on the 54 hours a week you would have worked at the time. I'm not sure I understand the 90% that you mentioned, but in terms of bonuses and RSP contributions, yes. What is the bonus you would have earned during a 11 to 15 month period? What is the RSP contributions they would have made during that time? All of that is what you're owed as part of your severance package. Absolutely. We have another question. I think this is one from YouTube being asked by Mr. Bilson. It states, I was let go for cost cutting in 2010. I was given minimum severance pay plus EI. Is there an expectation to this exception rather to the statute of limitations to get full entitlement? As I just discovered common law entitlements. Unfortunately, not, Mr. Bilson. So all of you listening, it's important to know that generally, if you're terminated and you're not provided with sufficient severance, you're entitled to go after more severance. You can do that through us, through a lawyer. A lot of our cases, we're able to resolve them prior to a lawsuit. Okay, we're able to get you more money prior to a lawsuit. But if we do have to sue, then we have a very important limitation period that we have to abide by, after which you lose your right to sue. Okay. So in the common law courts, in the court system, that limitation period is often 2 years. All right. And it's not because you didn't know that you had a claim, hadn't heard that you could get common law severance or what we call full severance. You hadn't heard of that. That you can extend that 2-year period. Unfortunately, that 2-year period is pretty much set in stone. It's very hard to get around that 2-year period, unfortunately, Mr. Bilson. And what I would like to also point out is that if you have a human rights claim, you have even less time. You only have 1 year from the day of the last discriminatory event to bring your human rights claim. So it's very important that you not sit on this. If you have questions, you're doing the right thing. If you have questions, tell your friends. Why don't you jump on the show, hear what they have to say? Or why don't you reach out to us? We talk to hundreds of people every week about what their human rights entitlements, their severance entitlements are, and how we can go about helping them get that. So feel free to reach out to us. If you have a friend that it's just been terminated, let them know about us. That we're here to help. And unfortunately, what we find is there are a lot of people that were in Mr. Bilson's situation that just didn't know that they were entitled to more, right? And that's very unfortunate. And that's why we do this show, to try to get that information to as many people as possible. And you can help us in doing that. We're just sharing with your friends and family that there are lawyers out here that want to help them get their fair severance. We have another question coming in from Kathy McInnes Contogianis. I hope I got that right, Kathy. Kathy asks, if a person feels that a company has harassed them on the basis of accommodation and other historical maltreatment, and a person wanted to put in a legal claim, what is the time frame limitation to make a claim against the company that you work for? Is it within a certain limited amount of time that a claim would have to be started? So yes, just as I was touching on just now, Kathy, it's for a human rights claim, it's typically a year, all right, from the day of the last event. So in the context of discrimination in the workplace, human rights discrimination in the workplace, it could be that there's a series of events, right? They start by denying your accommodation. Then they reassign you somewhere else because they don't like that you asked for an accommodation. Then they start making fun of the fact that you have a disability, for instance, if you were claiming a disability accommodation, and those things might have certain dates. And so if you can show that there was a pattern or a connected series of events, then it would be from the last date, right? So if they denied your accommodation 3 years ago, but they're continuing to harass you because you have a disability today, then it would be a year from today, right? That you can bring your claim. If all they did was deny your accommodation 3 years ago and nothing else has really happened since, then you're out of time. You should have sued 2 years ago at the latest. You might still have a claim under just the court system without alleging human rights discrimination, and then that's 2 years from the day of the event. We have a question coming in from Marcus Sylvia. Marcus is asking, company changed the commission scheme and my territory unilaterally. This reduces my pay commission in more than 50%, and work conditions have degraded. Not to mention that now I have less sales possibilities. They seem to be forcing me and other employees to leave while hiring new employees. So right there, what jumped out at me, Marcello, is that your commission is down 50%, and it's not just because they changed the scheme. It's also because they're taking territory away from you. All right, so that can amount to a constructive dismissal. So basically, when that happens, you have a choice to make. You have to decide whether you'll accept the change. Say, okay, I'm fine with this. I'm going to make more money, but I need this job, whatever it is. But I'm fine with this. Or you're going to say, well, actually, I'm not fine with this. And in fact, I'm going to claim that you've constructively dismissed me. You've changed my working conditions so much by, for example, reducing my compensation by 50%, that I'm going to treat it as though you've terminated me. I'm going to quit, and I'm going to require you to pay me severance because you forced me to quit. Now, this is a tricky area of law for someone who's not a lawyer. So I always recommend that you contact us first and deal with this through a lawyer, because you want to make sure you're not saying the wrong thing. So sometimes having that communication done with the help of a lawyer can be very helpful to make sure you don't inadvertently accept the change when you don't want to, or something like that, or inadvertently wait too long to tell them that you don't want to accept the change. Because the thing is, if you can accept the change simply by continuing to work for a certain amount of time, you might be viewed as having accepted the change. So if you're like, well, they've changed my commission, then you wait a year and say, well, actually, what you did a year ago, I'm not happy with. It's too late. You've worked for it under the new commission structure and all of that for a year. The employer is entitled to consider you to have accepted the change. All right. So you have to kind of make up your mind very quickly. And I'm not a huge fan of this rule personally, because I think it puts a lot of pressure on employees, but it is the rule. All right. So you shouldn't sit on this. If you're considering that this is unacceptable, you don't want to accept this change, it's important you contact us as soon as you can, so that we can discuss what getting an exit package would look like in your case. We have another question from Sam. Sam was the one with the very nice compliment earlier, and he's asking, is there any similar brother or sister channels that can outline key talking points as it relates to USA employment laws? That's a great question. I am not aware of anyone in the U.S. doing things similar to us. Doesn't mean they don't exist. I'm just not aware of them. One resource that can often be also great is LinkedIn. I'm on LinkedIn. If you want to look me up on LinkedIn, our firm is on LinkedIn and we're posting a lot. Samfiru Tumarkin is on LinkedIn. And I suspect other employment lawyers, including US-based lawyers, are on LinkedIn as well. A nice place to start, maybe in the US, if I can just give you some advice, is the Department of Labor. Maybe has a LinkedIn channel that might be helpful as well. And I gotta stress that a lot of what I'm saying in this show applies really to Canada, and I know for a fact that employment laws in the US are quite different from what they are in Canada. We have another question coming in from Jan. Jan asks, was written up and threatening for termination for not stopping or no stop signs and putting chains on truck. Okay. All right. So Jan is making the point that essentially you were reprimanded, I guess, for your driving technique. So I think the employer, if they did take issue with the way you were driving, they did it the right way. Rather than terminate you right away, they gave you a warning first. All right. So some people think that it's unfair that they even get a warning. I don't have all the details of why they asked you to stop when the road signs did not require you to stop, or what issue they take with you putting chains on your tires. But if that's a clearly stated policy, you can't have chains on your tires, and they catch you with chains on your tires, then the normal procedure would say, well, this is a violation of policy. Had you been made aware of the policy, they would check to see if you ever signed off on the policy. If you were aware of the policy, why didn't you follow the policy? They would ask you, and then you would tell them whatever reasons you had for not following the policy. And if they were unsatisfied with those reasons, for instance, you think the policy is dumb or something like that, they'll say, well, it's not about what you think, it's what we asked you to do. So here's a written warning. Please no longer put chains on your tires. And if you continue to do that, then it goes, the discipline escalates to the point where they've tried everything they can to get you to follow the policy. You're not doing it. You're not doing willfully, even though you know it's against the policy. Then that kind of opens the door for them to terminate you on a for-cause basis. And if you're terminated on a for-cause basis and that's upheld, then you're not entitled to severance. Right? What I see a lot is people jump straight away, the most minor thing, they'll jump straight away to termination for cause. And that's the wrong way to do it. In fact, the employers really do have an obligation to consider progressive forms of discipline. And that means from going from the verbal to the written to the suspension to termination. All right. So one incident is usually not going to be enough to terminate someone for cause. So I think your employer seems to be aware of that and is going through the steps now. So you need to be aware that at the end of this, if you continue with this, they might terminate you for cause and that might disentitle you to severance. We have a question coming in from Dan. Dan says, thanks, Lluc. Follow up. If I am not mistaken, the Alberta Employment Standards Code says that it is up to the employee to decide if vacation can be split if the employer is violating it and promoting mental illness. You know, you got me there, Dan. I thought I knew this part of the Employment Standards Code. I thought it was that they had to give it to you in blocks of 1 week. I am happy to look into that, Dan. What I propose you do is you reach out to us at employmentlawyer.ca. Tell them that I promised to look this up in the Employment Standards Code for you, and I can give you that answer. It'll take me a second. I just can't do it right this second, unfortunately, right in the middle of the show. My recollection was that they had to give it to you in at least blocks of 1 week. But it might be that it's 2 weeks. Maybe I'm misremembering that. But that would take me 2 seconds to look up, and I can't do it now, but I'd be happy to do that for you. But that's what I was referring to. Yeah, basically the employment standards governs here. And if the employment standards says that, you know, it can be broken up into less than a certain amount of time, then your employer can't say otherwise, right? If your employer says, well, I don't follow the Employment Standards Code, then you just pick up the phone and call Employment Standards and say, my employer doesn't think he has to follow or she has to follow the Employment Standards Code. You know, what's up with that? And they'll make sure that your employer is compliant with what the Employment Standards Code says. We have a question on YouTube from Wolf. Wolf is asking, the store I work at had an eviction notice posted on the entrance. If I'm unable to return to work because of this, am I owed severance? Yes. If the employer can no longer employ you because they don't have a job for you to go to, then you're owed severance. Absolutely. They haven't used the term "I'm terminating you," but essentially, you've been terminated, right? So reach out to us because that's a termination in my view. That's a very black and white question. Unless they can say, well, listen, actually, we got a new store opening up down the street. Give us, you know, a couple of days. Shouldn't be a couple of weeks even. It should be a couple of days maybe. But other than that, if they've kind of fallen off the radar and paying their rent, don't have a shop for you to go to, then it looks like you've been terminated and you're owed severance. We have another question from Facebook from Patty. Patty is asking, if I initially requested to be on parental leave for 18 months, am I allowed to change the return date to an earlier time? I would again, this is going back to the Employment Standards Code, because the Employment Standards Code talks about parental leave. But my recollection is that, yes, you can request an earlier time. You'll have to ask for plenty of notice. You'll have to give plenty of notice to your employer because they might have hired a temp to replace you while you're gone, and they need to make arrangements for that. So that's the one concern I would have. But definitely reach out to your employer. I would say reach out to us if they object. What I've seen happen is that, you know, people request 18 months and their employer says we can only give you 12. That's not the law. You're entitled to take the 18 months. Under employment insurance legislation, you can take the parental leave, you take a lesser amount for 18 months rather than the full amount for 12. And so that entitles you to then take the 18 months if you choose to. So that's the position I would take on that. Again, a quick check on the Employment Standards Code should clarify that. But if I do recall correctly, you are entitled to go back earlier if you're ready to. Like I said, from a practical perspective, they need to be ready to take you back. And if they hired a temp, you need to kind of figure something out with your employer. So first things first would be to reach out to them. If it is becoming a bit of a problem, I would say reach out to us at employmentlawyer.ca. So that takes us to the end of the show. My name is Lluc Cerda. I'm the managing partner of the Calgary office of Samfiru Tumarkin. It was great having you all on the show. Feel free to reach out to us on LinkedIn. Like I said, we have a lot of information on LinkedIn, on Facebook, as many of you are aware, on YouTube. We try to get to people where they are, so feel free to reach out. We'd love to hear more from you. And we're back again on Wednesday with Lluc Samfiru. We'll be here answering your employment law questions related to anything that you're dealing with at work. So thanks for tuning in, and hope to see you soon. Bye now.